Afternoon, everyone. Thank you for joining us for today's live redundancy Q&A. We'll do our introductions first, and then I'll just set a little bit of context about why we set up today. So my name is Gavin Howarth. I'm the Managing Director of Howarth. I also qualified as a solicitor 10 years ago. So I still do a fair bit of advisory work, but also for the last 7 years I've been running the business.
Hello, I'm Charlotte Geesin, Head of Employment Law. I've been at Howarth's for nearly 9 years now, and like Gav, previously qualified as a solicitor as well. Provide advice to SME businesses on all aspects of redundancies, restructures, changing T's and C's. So hopefully any questions that you fire at us this afternoon, one of us will be able to answer, no problem.
So just a little bit of context about today then. So as a business, we advise around 500 SME businesses, ranging from those with 1 or 2 staff up to the biggest has around 500 staff, and anywhere in between in any different sector. And as you all know, at the moment, it's, I suppose, incredibly tough times. The job retention scheme has been in place for a number of months now, and has kept people in work, but it's now starting to taper off bit by bit as the months roll on. And we're seeing as an advisory team a lot of redundancy queries, unfortunately. So, from across our client base in different sectors. So all of us in the advisory team are unfortunately advising businesses on a number of redundancies, some looking to reduce, big teams of people up to 15, 20 people, even 90 people, and others smaller redundancies, 1 or 2, but still a lot of redundancies. So when we sort of started to talk about this as a team, we thought the best thing we can do is we'll create a webinar, and we want to give as much value as we can in the half an hour we've got to help businesses with the sometimes tricky area of redundancies. So Charlotte and I have teamed up, as we both said, collectively around 20 years experience and advising on lots of redundancies over the years and lots of different SMEs. And we hope the combination of the two of us with legal knowledge, but also a lot of practical experience, will be able to add as much value as possible. So it is a live Q&A. So we'll try and answer as many questions as we can. But before we get to the questions, Charlotte is just going to run through a few logistical points about how we're going to run today's session.
Just before we launch into things, like Gav says, just a few practicalities, technicalities in terms of how we're going to run the session this morning. Audience participation will be required. This is a live Q&A, so we do require your input. Aha, excellent. We've got our first participant. Well done. We are going to accept questions exactly in that way via the Q&A box. So if you have a question, by all means type it in there. However, we're going to prioritise live questions. So if you do have a question, if you click on the function at the bottom of your screen with a little hand saying raise hand, then that will alert us. We will bring you into the mix. You won't be on video, so don't worry if you're sat at home. That's absolutely fine. However, your audio will be switched on, and we can have a quick chat and do our best to answer your questions. Any questions that are asked via the chat, the chat function won't be answered, so please use the Q&A box. Any questions that are submitted via the Q&A box, we'll do our best to answer now, but if we can't, then as per previous webinars, we will be prepping a follow-up note for publication following this session that outlines all the questions that were answered. We'll make sure that everybody is kept anonymous, and that will be released very shortly, so hopefully you'll be able to see details of your question there. We'll do our best, obviously, to provide as much detail as possible in respect of all your questions, but obviously we're limited for time, and redundancy is an area which throws up many technicalities, and obviously a lot of the advice is very fact dependent. So we'll answer as much as we can generally, but we will probably be suggesting in a few cases that actually you just pick up the phone to us after this session and have a chat through any specific questions that you have to make sure that we give is absolutely spot on and suited for your needs. Like Gav said, 30 minutes, but I like to chat. Gav likes to chat even more. So it might be that we run over slightly, but please do bear with us. Right, okay. So I suppose we can kick off then. Gav, what do you reckon?
Yeah, let's do the first Q&A. Do you want
Yeah, okay.
start off, Charlotte?
Sorry,
do you want to start off, Charlotte? Yeah, on the Q&A.
Yeah, I'll start off. So just before we come to the question that's just cropped up, there were 3 questions that were asked prior to this session. They were corkers of questions, I tell you. And the people that submitted them, I'd ask you to give us a ring after the session to talk through them. But in general terms, some of the key points that came out of those questions, I think are valid and quite interesting. So one of the questions was around hiring people whilst at the same time as making others redundant. And the question essentially was whether that's permissible. The short answer is yes, it's absolutely fine. There is no problem with you making redundancies in one area of your business if you have a genuine business need to make cuts there, while simultaneously adding staff into the mix elsewhere. The only sort of practical legal consideration that you need to have if you're running 2 simultaneous processes is whether or not the roles that you're recruiting for could actually be said to be classed as suitable alternative employment for those who are at risk of redundancy. In the event that that is something that you think actually is probably the case, then the employees who are at risk of redundancy should be given first refusal over the new jobs before you widen out that application process, either internally or externally. Questions then sort of followed on, knocking on the doors of collective consultation, every employer's favourite process. Collective consultation, as some of you will know, is a statutory process that employers have to follow when they are looking at making more than, or proposing to dismiss as redundant, to quote the legislation correctly, more than 20 employees in the space of a 90-day period. Where that happens, the employer has to follow a collective consultation process, which essentially means you have to consult with your staff for 30 days. There are some additional obligations to comply with prior to the onset of the consultation, including notification of unions and election of representatives. But once those sort of primary obligations have been met, the consultation process, albeit running for longer, can run in a very similar fashion. Where you have multiple sites and you're looking at making redundancies across multiple sites, collective consultation is something to be aware of, because if you're looking at proposing to dismiss as redundant more than 20 people across those sites, you may have to consult. Collective consultation is really fact specific though. So as I've said, if the person who submitted that question would like to get in touch afterwards to discuss it in more detail, then by all means, please feel free to do so. Third question focused on the acquisition of sites during this time and looking at making cuts post-acquisition to the staffing numbers. The question was around what sort of things do we have to kind of consider, and I think that the main point to consider is that this will be a TUPE process first and foremostly, and the redundancies will be wrapped up within that process. Where there is a proposal to make people redundant following a TUPE transfer, the process can be fairly complex in the sense that it splits into 2. You have your pre-transfer consultation obligations with the staff, so that's before they come into your employment, and then you have your post-transfer obligations as well. The pre-transfer obligations, the relevant legislation is the TUPE regs. And that's about notifying the staff and the outgoing employer of your intended measures with regards to redundancies. And the post-transfer process is the consultation process with the employees. It's the process that you'll follow to actually confirm their employment as redundant. You can't take any action pre-transfer in terms of the actual dismissal process, but you can lay the foundations, and obviously you're under an obligation to actually lay those foundations anyway. But again, 2P, redundancies, getting up there for you sort of more complicated issues. So again, would invite that person to contact us for some advice. So hopefully the 3 people who submitted those questions are listening and that helped. But yeah, Gav, I don't know if you've got anything to add on any of those sort of general points.
No, actually, I haven't. I was all prepared to do so, but I think you've covered everything there, Charlotte.
Good. Okay. So on to the Q&A box then. Do you want to take the first one, Gav?
So the question asked is, what are the requirements around offering alternative employment? For example, where we have 1 vacancy in another area of the business, but 3 redundancies, are we obliged to retain 1? Or is an open interview process acceptable to which would invite them to apply? So yeah, this is all about the search for alternative employment during a redundancy consultation process. So just to start from the top, when employees are at risk, clearly you've got to go through a consultation process. Charlotte touched on the fact there that if there's more than 20 people at risk, then you're in collective consultation. But even if there are less than 20 people at risk, you're still obliged to carry out a consultation period, which is crucial to a fair redundancy and a requirement. So when you do a consultation process, you're clearly talking about the business case, you're talking about the reasons why the redundancies are needed. You may have scoring, you may talk about pooling, they're all fact specific depending on the circumstances. But one thing you will certainly need to do is look for ways to avoid the redundancy. Now, at the start of the process, that'll include more general measures, including, can we lay people off? Can we put people on short-time working? Can we look at pay cuts, perhaps, changes to terms and conditions? Looking at all ways to keep people in employment. But as you progress through the process, you'll also be talking more specifically around, can you find alternative employment around the business? So that's you as an employer looking for alternative jobs which may be available, which those at risk could do, and therefore saving their employment. So in respect to the question here around where you have 1 vacancy in another area but 3 redundancies, yeah, I suppose the facts would be important, but are we obliged to retain 1, or is it an open interview process acceptable to which would invite them to apply? So if it's a different role than the one that the 3 are doing, yes, you would bring it to the attention of those at risk. And I think good advice and good practice would be to bring any job which is available to the attention of those at risk, not just ones that you think they might be interested in. You should bring any job available and let the employee decide whether they're interested in it or not, even if it means a pay cut. So you'd bring this to the attention of those that are at risk. And yes, if you had more than 1 apply, then you could embark upon an interview process to decide which one would be successful. Charlotte, have you got anything to add to that?
Not massively. I agree with everything that you've said there. I think that perhaps it's important to note that the legal requirement when it comes to searches for alternative employment is arguably limited to searches for suitable alternative employment. Now, there's no definition of what suitable alternative employment means, but generally speaking, it's a similar type of job on similar pay with similar duties and benefits. And arguably, when an employer has an alternative vacancy that isn't suitable, it's just totally different, you wouldn't have to give the employees who are at risk of redundancy the opportunity to either apply for that role or be slotted into it. However, there is case law to suggest that even when a role is unsuitable, it should still nevertheless be offered as a possibility to avoid redundancy. And certainly that is always the approach that I advocate taking. I very much leave the issue of suitability to the employee to determine, because ultimately, if there's any risk in sort of employee issues, it comes from your employee. If they're unhappy, they might sue you. If they are happy or generally okay about a decision that's been made, then they're less likely to sue you. And in some respects, that's a priority matter for an employer. But overall, like I say, I agree with everything that you've said there. I think it's, you know, a fair assessment of the sort of obligation, really.
And just two additional interesting little points on that. When you're looking for suitable alternative, if you are a group of companies, just bear in mind that you may need to look across the group potentially, depending on what's reasonable. So take advice on that. And also, if an employee is working their notice period, i.e. you haven't paid them in lieu of notice, but rather they are working it, or indeed in this scenario on furlough, you're under an ongoing obligation to look for alternative employment to avoid the redundancy, even during the notice period.
Yeah, that's a really good point. And actually, just following on from that, I've seen it where employers get caught out on that by their own internal redundancy policies. So if you have a redundancy policy in place, read it, because it might say something in there about a sort of enhanced obligation that you impose upon yourselves to look for alternative work when somebody's at risk of redundancy, either in terms of unsuitable positions or, like Gav says, during the wider notice period. If you fail to adhere to your own self-imposed policies, then not only can that in itself render a dismissal unfair, but it can also present wider issues of breach of contract as well, one to be avoided, ideally.
Yeah. Okay, good stuff. So, right, we'll crack on with the next question. Charlotte, do you want to take the next one? We'll do it.
Yeah, collective consultation, all good fun. I think this is probably the $64 million question when it comes to collective consultation. Do you have to undertake a collective consultation process if you are making less than 20 employees redundant? The answer to that is maybe, yeah, because the legislation which governs collective consultation actually refers to the numbers of employee that you place at risk of redundancy. So if you are embarking upon a redundancy consultation process which sees 20 or more employees across an establishment placed at risk of redundancy, then whether or not you only intend to make 1, 5, 10, 15 of those people redundant, collective consultation will still apply. Like I said, sort of when I sort of mentioned those questions that have been asked pre this session, it's really important to take advice on collective consultation processes to make sure, A, you've got your pooling right, but also to ensure that you are clear as to whether there is indeed an obligation to collectively consult. Because if there is an obligation to collectively consult and you don't, then not only do you run the normal risks of unfair dismissal, but there's also protective awards that can be issued too.
Yeah, and just to add to that, the definition of redundancy under the Act, which says that you need to collectively consult, doesn't just include making redundancies. It can also include changing T's and C's. So if as part of the process, you're making a certain number of redundancies, but also then you have a group of staff who are agreeing to go, for example, for 5 days down to 4, change T's and C's, then both those numbers added together may take you over the threshold for the requirement to collectively consult, because the definition is wide. So again, like Charlotte said, take advice if collective consultation is even a consideration.
Yeah, that's a really good point, actually. And just sort of further clarification on that, you might not actually be proposing to dismiss anybody as redundant. You might only be proposing to change T's and C's. But if you are proposing to change T's and C's of more than 20 people, even if you're not looking at sacking anyone, collective consultation may still apply.
Yeah. Okay, right, next question. 21 minutes past 10 already. We're only just getting
time flies.
Next question. We have provision for layoff and short-term work stated within our contracts. What's the practicalities of both, and how does the selection criteria work? Okay, so this is a question around what I suppose what I would call now traditional layoff, before furlough came around, and we started talking about that being layoff. So traditional layoff, which is that you can lay staff off for a period of time, and only be required to pay them a statutory guarantee payment. You need a clause within the contract to be able to do that. The employee needs to expressly agree to it. That's layoff. Short-time working is very similar, but just working less of a given week. So they should be within the contract of employment already, and they certainly should be something that employers think about before embarking on redundancies. If you remember in the answer to the last question, I talked about the employer needing to show that they've thought about ways of avoiding the redundancies. And when furlough, the job retention scheme does come to an end or start tapering down, employers should be considering things like traditional layoff, short-time working, as I said before, reduced hours, that type of thing. So it's a good question, certainly something you should be considering. What are the practicalities of both, and how does the selection criteria work? Well, we probably haven't got time to cover all the practicalities of layoff and short-time working, but actually, suffice to say that it's quite a simple process with layoff and short time, because the employee has expressly agreed that you can do that if it's in the contract and the contract is agreed. So of course, as with any action employment law, and certainly any clause within a contract of employment, an employer is under a duty to act reasonably and with trust and confidence. So you still need to act reasonably, but you can just bring layoff and short time working into place, give the employee notice, make sure you write to them, and follow the right procedures about statutory guarantee payments. It does get a little bit complicated as time goes on, because the employee may have a right to be able to claim redundancy if they've been on short-time working or layoff for a certain period of time. So again, take advice around that. In terms of the selection criteria about who goes on layoff and short-time working, it's really, there isn't a formal one per se. Again, it's about being reasonable, and it all comes down to a business case of who you need in the business and who you may have a business case that you don't need for a period of time. So there isn't a specific criteria to use, although if you had a group of people that all do a similar type of work and you couldn't decide who to do it, then you may choose a criteria akin to what you would use in a redundancy selection process, to choose who is laid off, and in fairness terms, then maybe rotate that group of people over a period of time so that everyone's impacted in the same way. Charlotte, did you have anything to add to that?
The only thing that I was thinking was sort of in practical terms. So obviously, Gav mentioned the furlough scheme is going to end in October, and it's going to start tapering down now. But I don't think that come 1st of November, the economy is going to magically bounce back, and employers are going to be in a position where they've, now got work for everybody, if not more people. There's still going to have to be difficult decisions made about staff, the allocation of work, etc., etc. Now, redundancy remains an option following furlough, absolutely. And if you've got a reduction in work that necessitates that, then fine. However, redundancy is costly. Particularly if you're making long servers redundant, you've got the notice pay obligation and the statutory redundancy pay obligation. And in some cases, you're looking at thousands of pounds to get rid of someone. Now, come 1st of November, we don't know how the land is going to lie, and it might be the case that employers have a reduction in work, but simply can't fund a redundancy situation, or they don't want to sort of go as far as making people redundant because they don't know how things are going to happen. They might be hopeful that things are going to pick up, etc., etc. So layoff and short-time working, I think, are going to be sort of options that a lot of employers are going to perhaps want to explore or need to explore come November, because effectively what they will do is kind of extend the period of time that you keep your employees away from work but retain them in their employment. Obviously there's no payment attached to that, although if you wanted to pay them sort of a company funded furlough scheme, that wouldn't be an issue in principle. But the basic layoff short-time work allows for an employee to be at home with no payment other than the statutory guarantee payment. So perhaps start thinking about that now if you are looking into the longer term, the practicalities of layoff, short-time working, see if you've already got a contractual right to do it. Because like Gav says, if you have, then actually logistically it's very easy to implement a layoff or short-time working. And there is no minimum or maximum amount of time which someone can be either laid off or placed on short-time working for. It's meant to be a sort of a stopgap measure. So we wouldn't sort of suggest that you keep someone on layoff for 6 months or 12 months, but certainly, you know, between the 1st of November and the start of the new year may be an option. Employees can request to be made redundant after 6 continuous weeks of layoff or 13 non-continuous weeks of layoff. So again, maybe something to factor into your timetable, and if you're looking at doing this across your workforce later down the line. But it's not an automatic right. If you can show that you think work is going to be improving at some point, then you're entitled to push back on that request for redundancy.
Yeah, and I just a very good point that when I talked about looking for suitable alternative employment in a last answer, and this point about alternative to redundancies, write it all down, keep an audit trail, even your thought process. So what search you for alternative jobs, and in answer to this question, you know, what considerations you've taken to avoid the redundancies, because an audit trail is really important. If it doesn't happen in tribunal, all the audit trail is really important. Yeah,
definitely. So in terms of the next question then, not ignoring you, Gary, but just to answer Gareth's question, which was just popped through now, given that it follows on from what we've just been talking about. Short-time working won't constitute a change in T's and C's if you already have a contractual right to place someone on short-time working. Check your contracts to see if you have that in place already, and or any letters that you've issued to your staff who may have been placed on furlough leave since March, because that may have built in a contractual right to place people on short time following the end of the furlough period. If you don't have a contractual right to place people on short-time working, then it may well be something that you have to collectively consult about. But again, specific advice on that would be needed in due course, I think. In terms of the next question, is it reasonable business case to say that a role is simply no longer required? Maybe. If we look at the legislation that underpins redundancy situations, it's section 139 of the Employment Rights Act. And what that says is that in order for there to be a genuine redundancy situation, there has to be a reduction or cessation in work of a particular kind at a particular location. Now, the legislation doesn't go any further than that, and case law is on sort of business cases, if you like, is limited, because a tribunal is not permitted by law to sort of delve too deeply into commercial matters and into business decisions. So as long as an employer can show that they have a business case which feeds into that statutory definition about a reduction of work of a particular kind, then generally speaking, they will have satisfied that primary legal obligation. Now, it is therefore arguably okay to simply say you're at risk of redundancy because your role is no longer required. You are entitled to make business decisions about how your workforce is structured, what roles you have in that structure, where they sit, and all that sort of stuff. However, if you're going to place someone at risk of redundancy on the basis that their role is being deleted, you are going to have to explain the thought process that has led to that deletion, if you like, coming to the fore. You can't get away, unfortunately, with just saying to someone, oh, your role's no longer there anymore. You're going to have to explain why. But provided you can provide that why, and provided the explanation is objective, commercial, rationalised, etc., then I personally can't see any issues with that satisfying the section 139 requirements. Do you agree, Gav? Hope so.
Yeah, largely. I think you're right. The truth is, if you end up in an employment tribunal, putting it as simply as possible, if the business case looks sensible and strong and it isn't a cover-up for something else, i.e. clearly the business has fabricated a business case to remove someone who's underperforming, then the tribunal won't delve into it that much, because how can they? They don't work. The judge who sat there on the day has never worked in your marketplace. So if you're telling them that customer demand is down, you've changed service, you've a different way of addressing the market, then they'll take that on face value because they're not experts in your industry, unless it looks dodgy, for want of a better word. So yes, so that's one angle, the employment tribunal bit. The other one is to the employee, like you referenced, Charlotte. And, you know, I don't think an employer can underestimate the impact a redundancy would have on an individual. You know, it can be devastating for people, their families, etc. And people can be in shock when they hear the news. And I think the more that an employer attempts to explain the business rationale, the better chance you've got of the employee understanding it, accepting it to a degree, maybe even reluctantly, but accepting it. I think it's where, in my experience, employers sort of act too quickly, don't take the time to explain things, almost try and rush it through, that you usually then end up with problems afterwards because it's all too much of a rush. The employee's in shock. So I think, yes, in a strict sort of legal sense, as long as, you know, it looks legitimate, but I think you owe it to the employee to give a decent explanation. Okay, good. So, right, let's move on to the next one. Sorry, we are 3 minutes over. We have 2 questions on our list, so we'll crack on with these last 2 as quickly as possible to respect everyone's time, and then draw to a close. So, next question. We intend to put at risk both of our team leaders and will be pooling and scoring them. However, we also have a line leader who is basically an apprentice team leader in training. The plan was for them to step up to team leader in the future. Should that person be included in this pool or not? So, good question. This is a question around pooling. So this is where you're deciding work of a particular kind is ceasing or diminishing. That's the word in the legislation. So there's some work reducing. Next question is, who does that work, to determine who is in the pool at risk of redundancy. And ultimately, it's up to the employer who's in the pool. Again, you've got to be reasonable about it, but it's the employer's decision who you pool. And typically speaking, an employer will want the pool as small as possible because it's easier to manage, less employees are impacted. Naturally, the employee will want the pool as wide as possible because the more people in the pool, the less chance of them going. So when you're pooling, you always have this natural tension, I would say, of the employer wanting it small, the employee wanting it big. And there's no right or wrong answer in a given case. It's just, again, about being reasonable and about showing an employment tribunal that you've thought about it carefully before getting there. So in this case, it really depends. So there's the work of a particular kind. So clearly here it's the team leaders that are the team leader role, the work that they do that is reducing. And it's then a question of, is it reasonable or not to include the I suppose, apprentice team leader? Now, without getting too complicated, there is some considerations around apprentices. So I'm not sure whether you mean that this team leader is actually an apprentice. Sorry, the line leader is an apprentice, or whether you just mean that as in they're training up to be a team leader. If they're an actual apprentice, then we need to be careful about apprentices and depend what contracts they're on. That's just a tip for everyone as well. If you're dealing with redundancies and you have apprentices, just take some advice on that before you go ahead and make them redundant. There's some special laws around apprentices. So if you don't mean that and you just mean a line leader who is training up to be a team leader, I suppose the question is whether they do the same type of work or not. And it sounds like they might not. Salary will be an indicator as whether they do the same type of work, are they paid the same? And really you've got to look at the tasks that they do, the experience the people have, and whether it was reasonable or not to pull them and make a call on it. So without knowing all the sort of facts of that, it's maybe a hard call, but yeah, possibly, I suppose. Charlotte?
Yeah, I don't have anything to add on that, really, other than sort of highlight the point that pooling, whilst there's no right or wrong approach, is all about the work of a particular kind that's ceasing or diminishing. Whenever you're looking at whether someone needs to go in the pool or not, you should always go back to the legislation, I think, because that will give you your answer. And ultimately, if your decision is called into question by your employees, if you can tie it back to the legal provisions, it's going to be harder for them to challenge. I suppose actually now I'm talking, there is a sort of a complicating factor when people do interchangeable roles, or, you know, so you've got a line leader that sometimes covers for a team leader or vice versa, or you've got people with interchangeable skills. So actually you think that Jeff could do Chris's job if Chris was on holiday or Chris was made redundant. You know, what does that mean in terms of the pool? And arguably where there are interchangeable skills or interchangeable job functions, then that means that all of those relevant individuals should be included within a pool. I think that kind of approach can start complicating pooling, and if you can stay away from that as best you can, then you should, but it's not something that you can necessarily ignore if it's genuinely the case in practice.
Yeah, agreed. So last question.
Yeah, this is like the $64 million question on normal non-collective consultation. Do we have to pull part-time and full-time employees, even though we only want to reduce the workforce by the part-time hours? This is a vexed question, and it's been vexed for years. The court's not the right answer, the case law's all over the place. But if you look at the principles again of section 139, which is all about work of a particular kind, there's a very strong argument to say that employees who work full-time and part-time but who do the same work should indeed be pooled together, even if you are only looking at reducing either the full-time function or the part-time function. There's no satisfactory authority at this moment in time that distinguishes part-time work as work of a particular kind from full-time work. I say vexed question, but that's the sort of legal position as it stands. And my advice would always be to err on the side of caution and include people in the pool. I don't know how you sort of feel on that, Gav.
Yeah, I agree. That's exactly what I was going to say, is the same thing, that I'd include both in the pool because of the uncertainty around the case law and the legislation and the argument that it's a different work. I'd include both in the pool and go from there.
Yeah, and the way that you deal with it in practice, you put everybody in the pool, everybody at risk of redundancy, or you're full-time or you're part-time. You explain what your new structure is going to look like for everyone, and then you make everybody apply for a position in the new structure. So you might have part-time people saying, oh, well, there's only full-time positions available and I don't want to work full-time, I've got childcare or whatever, I don't want to work full-time. Nevertheless, they still apply, and then if they are successful, they then seek to make a flexible working request once they have been successful in appointment. It complicates matters, but that's the sort of legal process that you would have to follow in a case like that. Fun and games.
Yeah, good stuff. Well, so that brings us on to 10:40 exactly. So my apologies, we are 10 minutes over, but hopefully you found that useful. Like I said, the whole point of today was to give as much value as possible. We're running the session again this afternoon, so feel free to come on this afternoon again if you want. There'll be different questions. We'll probably talk about different topics. And then, of course, as Charlotte said throughout, any further support and advice you need, just give us a call and get in contact, and we're more than happy to help. So otherwise, that's a thank you from us. Have a great Monday and hopefully catch up soon.
Bye.
Thank you, Gav, and thank you, Charlotte. So thank you to everyone for attending. You will all receive an email in the following days with answers to the questions that have been sent in, and also the recording of the webinar if you want to rewatch it and look at the answers. Now, I know we've got quite a mix of clients and non-clients online. Any clients with further questions, just get in touch with your advisor and they'll be happy to help you further. Anybody who isn't a Howarth's client that want to know more about how we can help, or interested in the services, then just get in touch and let us know. We can advise on anything and support with ongoing employment law, HR and health and safety support, to on-site support with things like redundancies and COVID-19 audits and risk assessments. So just call 01274 864 999 and ask for Louise, or email me, and the email address is louise@howarths-uk.com. Hopefully you found today interesting. We've also got another webinar coming up on the 10th of August with Wendy Creswell, our employment law and HR advisor. So that's going to be on termination under 2 years service, and we're going to be running a 10 a.m. session and a 2:30 session. So you can either look at our events page, or I will send the link out with our follow-up email, and any feedback on today's webinar will be greatly appreciated. Thank you all very much for your time. Take care.